Hello, my name is Michael Tessaro and I prepared this presentation entitled We Charge Dead People, ASIC and AMP Superannuation Limited. And I'll be looking at the recent case by ASIC against AMP for charging dead people money pursuant to various life insurance policies and conduct that occurred for many years. I guess it's a pun on that movie, The Sixth Sense, where the young boy said that he saw dead people. In this case, it's clearly, literally a case of AMP charging dead people for various services. Now, introduction about myself. I'm a competition and consumer lawyer and I run my own practice of sale, legal consulting, which I've been doing for the last 15 years, and I help companies with competition and consumer law. Also, I do some expert consultancy work for various organisations such as LexisNexis, CCH and Wolters Kluwer. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline to the presentation is pretty straightforward. I'll do a quick bit of background, then look at the judgment of HESP in ASIC and AMP superannuation, and then finish with some commentary. Now, this particular case arose out of evidence that was provided at the Royal Commission into Misconduct in the Banking, Superannuation and Financial Services Industry, or the Hayne Royal Commission, back in mid-2018. And I think the interesting thing to note is that there was no effective action taken within AMP about various complaints that had been receiving about the fact they were charging dead people from as early as 2007. And it really was only after the issue came out of the Royal Commission and made big headlines across various newspapers did ASIC and the AMP take any real action in relation to this conduct. Now, ASIC's alleged in this case that AMP entities were deducting and retaining life insurance premiums and advice fees from various superannuation accounts of deceased customers, and that the conduct occurred between 2015 and 2019, and there was no entitlement to charge or deduct the premiums or fees. Now, that's the period over which the ASIC allegations run, but realistically, the conduct was occurring as early, if not earlier, than 2007. So when you really look at it, the conduct was going for a decade. And the contraventions that were alleged by ASIC were quite extensive. Firstly, alleged breaches of Section 912A1A of the Corporations Act, which is this obligation to provide financial services efficiently, honestly and fairly. Also 12CB1 of the ASIC Act, which is unconscionable conduct. Section 122D13, which is effectively providing services or not unable to provide services within a reasonable time. And then finally, Section 219A1C, which is a broad prohibition on a failure to comply with various financial services laws. The entities that were taken to court were a number of AMP entities, AMP Superannuation and NM Superannuation, which were both trustees. Then there was AMP Financial Planning, which was a provider of personal financial advice services. They ended up paying a penalty. AMP Life Limited, which was the entity responsible for issuing the various life insurance policies, it also provided administrative services for the trustees. They ended up paying a penalty. And then finally, AMP Services Limited, they were taken to court, but by agreement, the case was dismissed against that particular entity. Now, the various products that were involved, it has 2,156 customers, and as you can see, it was a wide range of super and life insurance sort of products that were covered. And even though there's 2,156 customers there, as I said earlier, the conduct went for many years more than the relevant period under the litigation, so there was many more customers impacted by the conduct. Now, ASIC sought penalties under the unconscionable and failure to provide services provisions of the ASIC Act, but didn't seek any penalties in relation to the 912, the efficiently, honestly provisions of the Corporations Act. And they proposed a penalty of 30 million against two of the entities, AMP Financial Planning and AMP Life. AMP thought that the penalty should be about 18 million. Initially, AMP did not accept that the conduct was in breach of the legislation, but they changed their view on that and consented to various orders. So just effectively, there was an argument about the size of the penalty. And as I said earlier, the proceedings were dismissed against the fifth defendant, AMP Services Limited. Now, the allegation was during the relevant period, various products that were issued by AMP Superannuation as a trustee were administered on this particular computer system called Compass, and various products issued by AMP Superannuation were administered by the U2 system. And the problems went back to the inability of this system to recognise that a particular person had passed away, and that accordingly certain fees that were being charged should be stopped. So effectively they had very old systems that weren't really up to the task of monitoring changes in the situation of the policy holder and implementing those changes automatically. And as you can see, the product administration systems did not consistently operate to cease or prevent the continued deduction of both premiums and advice fees after AMP Life was notified of the member's death. And they also were unable to refund to the members' accounts any premiums or advice fees that were incorrectly charged. So the unconscionable conduct arises from having known there was a problem and having done nothing about it, nothing effective about it. Now, here's an example that during the relevant period, after being notified of the death of a member, this is what happened. AMP Life continued to deduct and pay itself premiums on accounts of, and there you've got 1,139 members. As I said earlier, there were many more members. AMP Life continued to deduct advice fees from the accounts of 27 identified members. Now, that was a sample of all the members who had fees deducted from their accounts. The advice fees were recorded as revenue of AMP Financial Planning. Then AMP Financial Planning failed to return the amounts after the member's death. So there was no process for actually realising that money had been charged inappropriately and then returned to the members. And then prior to or upon payment of the member's death benefit, AMP Life failed to restore the premiums deducted from those members and failed to restore the advice fees deducted. So it wasn't just charging people inappropriately and without an entitlement, but then it was failing to give them the money back, which had been inappropriately charged. Now, the interesting thing here is the court found that the complaints had started to come in about this charging of deceased members as early as 2017, and that was over an 11-year period. So both AMP Life and AMP Financial Planning are receiving complaints and inquiries from representatives of people who've passed away, querying why they've been having premiums deducted from their accounts and also advice fees are charged. And really nothing effective was done. There was a lot of internal correspondence and recognition there was a problem, but nothing effective was done within the business until mid-2018, and that was only after the issue was raised at the Royal Commission, the Hale Royal Commission, and got, as I said earlier, an enormous amount of press about the fact that AMP were charging dead people for not only premiums for their life insurance, but also for providing financial advice, which clearly wasn't being provided because the person was dead. And then AMP decided to make a report to ASIC. They have a requirement under the legislation to provide reports of suspected breaches to ASIC. So they only reported this breach after it came up at the Hale Royal Commission. And then they made reports under 912D of the Corporations Act and also 297 of the Superannuation Industry Supervision Act. And they made further reports to ASIC in 2019. So here's a problem that's identified in the business from early as 2007. No actions taken, no reports been made to ASIC, and it's only when Hale Royal Commission uncovers it, and there's a lot of bad press, that anything effective is done. Now, the one thing that they did do, AMP, was they did implement a remediation program of their own volition, and by November 2019, they provided a breach update to ASIC, informing them that they had identified 9,308 members that had been affected by the conduct, and estimated the financial impact on those customers was $4 million. So as I said earlier, the numbers that are identified in the case are much smaller than the total number of people affected. In actual fact, it was over 9,000 members who were affected, and the damages were in excess of $4 million when you looked at all the various factors. Now, throughout 2019 and 20, AMP conducted this remediation program, and it provided refunds to 10,155 superannuation accounts of deceased members who were refunded either advice fees and or premiums, and the total amount that was refunded was $5.2 million to the representatives of the deceased members, and that comprised firstly the fees and premiums. So as you can see, $4.2 million together with lost investment earnings of $1 million. So $5 million of remediation was paid to 10,000 accounts, approximately 9,000 customers. So it was quite large compared to the conduct that was a subject of the litigation. Obviously, a lot of these customers were overcharged prior to the period that ASIC could take legal proceedings on the relevant legislation. Now, the first thing that was in favour of AMP in terms of the penalty that was to be awarded here was an apology. And as you can see, Mr. Cullen, the General Counsel of AMP, apologised to the customers for continuing to deduct and failing to refund premiums and advice fees, and acknowledged that that conduct fell below the standard expected AMP group. That's obviously a positive thing to do. It's just a sort of a strange person to issue an apology. The General Counsel of an organisation. Realistically, I think it would have had more weight had it been from the chairman or chairperson in charge of the organisation, or the managing director or CEO. It seems strange that the top legal person would issue an apology to customers. Then when you look at the revenue and profit of the organisation, you see they're very, very large corporations. You've got AMP Limited there. As you can see, $1 billion worth of revenue in 2015. A lot of fluctuation. Obviously, they've had a bit of a rough trot over the last few years, and you can see their net profit in a number of years is a negative. But even in 2017, very large profits. AMP Life, again, very large company, $7 billion there of revenue, quite large profit levels. And across the board, these are very, very large entities with large revenues and large profits. There's a lot of intercompany transfers as well. So some of these negatives here may not tell the full story if funds are being transferred within the group. Now, the causes of the conduct, I guess the judge put it into two categories. Firstly, continuing to deduct premiums and advice fees following notification of members' death, and then failing to refund premiums and advice fees deducted between the date of a member's death and the date of notification of the member's death. So there were the two types of conduct, and these problems arose from poor computer systems in the business, decentralized complaints handling. So they didn't have a central complaints handling system. Rather, there was a variety of different systems throughout the businesses. The processes for, or the procedures for improving processes were very cumbersome. So if somebody needed to make a change to the way the system worked, there was quite a long process of submitting a request and that being actioned by the relevant business units and IT teams. Furthermore, there was an inability to detect systemic and enterprise-wide issues. So fundamentally, they had a very poor complaints handling system. As you can see there, the judge noted they did not have a holistic oversight of complaints. So realistically, you want all your complaints to go into a central report, and then for those complaints to be analysed by people of some relatively high seniority to identify systemic issues, and that clearly wasn't happening here. There was no enterprise-wide sharing of complaints data, so complaints could go into various business units, and they weren't put together to show that there was a bigger problem than may have appeared to be the case. Also, as you can see, they couldn't identify a systemic issue. They also had 18 separate complaints management teams. So that's really diffusing complaints over a large number of different teams who obviously didn't talk to each other, and therefore they didn't get a full appreciation of the scope of the problem. Furthermore, there was no quality assurance system in relation to closed complaints. So this is just very, very basic errors in terms of complaints handling. You need systems that will amalgamate all the complaints you're getting, will code them in a certain way as to identify systemic issues, and then they have to go, a report at least, to somebody of some relatively high seniority. The compliance officer, who should be a person at senior management level, should be getting these reports and should be analysing them on a regular basis. And many companies that I do compliance work with are analysing their complaints data on a weekly or monthly basis. I don't know what was happening here, but it seems like none of this data was going through to anybody of any seniority in AMP. The penalties that were proposed, as you can see, ASIC was proposing 30 million and the defendant was proposing 18 million. But when you look at the maximum penalties, you can just see how large they would arise. Obviously, prior to the changes in 2019, the penalties weren't huge compared to, say, the Competition and Consumer Act. But then after March 2019, the penalties did rise very dramatically. And as you can see, the penalty there is ridiculously high. So it's a number that really can't be even considered by a court because it's just really too high as to make any sense. So when the judge was looking at the penalty, he listened to a submission by AMP that they should consider the course of conduct, and they reduced the course of conduct to, I think, 5 separate events. But as the judge pointed out, accepting that submission would have resulted in a penalty that was actually materially below what the defendants had actually submitted. So it's a strange submission to make to sort of say, well, we think it should be 18 million, but adopt a course of conduct approach which will result in a penalty significantly below 18 million. And the court also noted that it's really artificial to talk about the 27 identified cases where customers had been charged for financial advice, because it's well accepted by all the parties that this was simply a sample. This didn't tell the whole story. But when you're imposing a penalty, you've got to consider the whole course of conduct. And so there were material limitations in assessing the deterrence favour penalty by reference to a sample in isolation from the actual true nature and circumstances of contravening conduct. Also, in just assessing all the factors, I think the judge looked at, there were a large number of members affected. As I said earlier, probably over 9,000 members. It occurred over a long period of time. He said over 4 years. I think you'd probably say it probably happened over a decade when you look at the first complaints coming in 2007. Clearly, the conduct was unconscionable. Charging people money after you know you have no entitlement to charge them is the definition of unconscionable. He notes that deceased members were vulnerable, which sort of hit me as a bit strange. I guess they are vulnerable, but I think probably the better observation is that the relatives who are managing the estates of the deceased person would have been emotionally vulnerable and unlikely to have been familiar with the policies that their deceased loved ones had. So I think that was a good observation. And clearly, the death benefits the letters sent to the customers did not disclose the details of the policies that would have enabled the beneficiaries and the executors of the estate to really identify the amounts that had been deducted from the deceased members' accounts or charged to the deceased members' accounts. But that made it quite difficult for these beneficiaries and executors to recover this money. So as concluded there in the last sentence, this was very serious wrongful behaviour. Now, a number of factors went in AMP's favour. They cooperated with ASIC, not initially. Initially, they did contest the allegations, but then they changed their tune. I don't know why they initially challenged the allegations. It was really a no-brainer in my view. They claimed there was no involvement of senior managers, that the complaints were going to junior people. I think that's probably right, but realistically, if you have a system that's preventing senior managers from having access to complaints data, it seems to be your own fault. So I don't know if that really should have counted in their favour. Clearly, remediation is a relevant factor. They've sought to remediate customers, and there was no suggestion that remediation wasn't a fulsome remediation. The judge concluded it wasn't deliberate, but it does seem to me that if you're allowing yourself to operate such poor systems, that it is clearly a reckless action. And I think if you're talking about deliberate, that's one factor in their favour. But if you're reckless, I think that places it in a higher level of culpability. And he noted as well, Justice Hesp, that the company had finally introduced improved complaints handling processes. So the judge looked at some prior conduct, and realistically there was two cases earlier, AMP Financial Planning, where ASIC took action against it for breaches of the same provision, section 12DI3, and that was also charging fees for no services in relation to superannuation. Then there was ASIC and AMP Financial Planning again, which involved failure to comply with financial services laws. But the irony about these two cases, even though they predated the current case in terms of when they were heard and determined, the conduct overlapped with the conduct in this particular case. So the judge noted that he really wasn't able to count these as previous contraventions, in the sense that the company had breached the law, being punished, and then breached the law again. Rather, there were three cases that just highlighted the pathetic compliance approaches of AMP over a period of time, and they all overlapped, so they couldn't really have the penalty uplifted due to these two previous breaches. I think it probably highlights just how bad compliance was in AMP for a very lengthy period of time. So the judge concluded the contravening conduct was very serious. The focus was on AMP Life and AMP Financial Planning. They admitted to breaches of unconscionable conduct and not being able to provide services in a reasonable period of time. There were a large number of affected members over a significant period, and despite receiving complaints, no effective action was taken. He goes, while not deliberate, it was extremely serious, but I think while not deliberate, it was clearly reckless. I think that should have been an observation made by the judge. Now, he says that although the companies admitted contraventions in relation to these particular 27 members, the penalty imposed is not directed at retribution or punishment for the contraventions that affected those 27 members, but rather is directed to the entire course of conduct that gave rise to the contravention. So it would be artificial to see this as a penalty for 27 breaches in relation to 27 members. Rather, it's looking at all the conduct that occurred over a lengthy period of time. So ultimately, the judge did decide that a penalty of $18 million for AMP Life and $6 million for AMP Financial Planning was appropriate. So I guess ASIC suggested $30,000 and AMP suggested $30 million and AMP suggested $18 million. So it seems to me that the judge split the difference and went for $24 million. So I guess dropping the penalty in between the submissions of the two parties. Now, the contraventions found in the case were quite extensive. AMP Financial Planning was found to have breached all the alleged contraventions, so the corporations law breaches and ASIC law breaches are the same as with AMP Life Limited. With the two trustees, the breaches were limited to failing to provide services efficiently and fairly in contravention of Section 912A1A of the Corporations Act. And just a bit of commentary, it's a very poor conduct. As AMP is aware of problems as early as 2007, and it's very serious conduct. We are charging customers premiums and for financial services after they've died. And that really should send alarm bells. And that's the kind of complaint that should go to the very top of the organisation immediately because it's so bad. And it just says a lot about the culture in AMP that this particular allegation was kicked around at, they claim, junior levels for a long period of time and never came to the attention of senior managers. And that's somehow a defence for them. But realistically, if a system's set up to prevent senior managers from finding out about these things, that is highly reckless behaviour. I think the response was very slow by all concerned. Really, the first complaints were raised in 2007. No action was taken for 11 years. And only catalyst for action was the fact that it was raised at the Royal Commission in mid-2018, 11 years after the first complaints were raised, and it was all over the press. And at that stage, not only did AMP start taking action, but ASIC started taking action. ASIC admittedly didn't know about it, it seems, although it'd be hard to believe that none of these beneficiaries complained to ASIC about this conduct. So I'd be very surprised if ASIC didn't have some information about this. But anyway, once it got raised in the Royal Commission, that's when AMP fulfilled its obligation to report it to ASIC. So it reported to ASIC in June 2018. Then I don't really understand this, but like 3 years later, ASIC commenced the case. Again, it seemed very, very slow to me for ASIC to move on that particular matter. It seemed like a very straightforward case, and I just don't understand why you're not commencing proceedings very, very quickly in relation to that conduct. I think the other thing is the case that ASIC ran was very broad. It sued 5 different entities with 4 separate breaches of 2 of the Corporations Act and 2 of the ASIC Act. Again, it's running a bigger than Ben-Hur case. And then when it gets down to the final stages, it effectively drops off the 5th defendant. It cuts back the contraventions alleged against 2 of the trustees and then proceeds against 2 entities. And you're thinking, why doesn't ASIC think of running that narrow, tight case at the beginning rather than cutting it back at the end? And you have to wonder whether, if somebody's been alleged to engage in unconscionable conduct, whether the seriousness of that particular breach makes some of the other breaches pale into insignificance. And if that's the case, why run them? It seems to me that if you have a very serious contravention, you run that, and it makes it for a nice, compact, but a very serious case. But then you add on other breaches that aren't as serious, it's going to really not add anything substantive to your case. You're not going to get any more penalty in relation to a lesser breach of the legislation. So again, the importance of running tight, compact cases, focusing on the most serious conduct. ASIC really needs to learn this lesson at some stage. Clearly, the complaints handling system that AMP had were terrible. They'd been running systems that were totally inadequate and unable to do the job they were required to do. And I think they were reckless in failing to have proper complaints handling systems. Realistically, a complaints handling system has to amalgamate all the complaints in the organisation, has to have significant diagnostics associated with the complaints, coding the various complaints, identifying systemic issues, and being reviewed regularly by senior management. Realistically, at least on a monthly basis, reports should be going to the compliance officer, who should be at a senior management level in the business, and that person should also be reporting to the board on the complaints received, the major issues, and how an issue of this nature, this serious nature, never made it to senior management level for over a decade is quite remarkable. Was the outcome adequate? Hard to say, really. $30 million is not an insignificant penalty that ASIC was seeking. A $24 million penalty is imposed is a significant amount of money. I think it is probably a bit on the light side. I don't know why ASIC didn't seek a lot more than that. Even though the systems were to blame, I think there was a high degree of recklessness, and I think ASIC should have made submissions that AMP had been reckless in their approach to handling their complaints, that they'd acted much too slowly in relation to the complaints which it did receive, and accordingly a much larger penalty would have been appropriate. I think maybe even an extra zero would not have been inappropriate in this particular case, but I think it's a funny situation here where I think ASIC has to start asking the court for much bigger penalties. It needs to start putting much higher penalties to respondents in cases, and if the other side doesn't want to play ball with the higher penalty, then run the case. This is a case that ASIC would never have lost had it gone to trial, so I don't know why it didn't ask for more and then take its chances with the judge. So that's all I had. I think it's an interesting case, and it's a terrible example of a major corporation charging dead people, and hopefully not only AMP but all the major financial institutions have improved their complaints handling systems as a result of this and other cases. So if you have any questions about this presentation, feel free to give me a call or send me an email. Bye-bye.